Good morning from Long Island, New York. This is immigration attorney Kyce Siddiqi. And today we're going to be discussing green card denials based on a misrepresentation, or for a lack of a better term, lie, for lying. And we're not talking about a little lie. We're talking about something in which the US government believes is a substantial lie or a material misrepresentation. Now, this discussion is going to center on the context of a misrepresentation when the lie or the misrepresentation occurred at the time of the visa stage, where the individual went in for a visa appointment and the misrepresentation was made either at the interview or at the application. So there are many people that have applied for a green card based on a marriage here, who are individuals who arrive to this country through a tourist visa. And when you apply for a tourist visa, you generally are given something called a DS-160. And on that DS-160 or any other kind of immigration form that you're given, most of the times you are going to be asked about your marital status. Are you single? Are you married? Now, one thing that I have been increasingly seeing as a active immigration lawyer is USCIS, Homeland Security, also known as immigration, denying applicants because of a misrepresentation or a lie that was committed in the application, the visa application phase, when the person came to the United States originally as a tourist, or during the time of the visa interview. So, just to conceptualize this, there are people here who have arrived as a tourist and ultimately have married a US citizen and are now applying for a green card. Well, keep in mind that whatever you said to get here, in other words, whatever you said to the US Embassy officer at the time of your tourist visa or your non-immigrant visa, is definitely going to be relevant when you are now in the United States and applying for a green card. So that misrepresentation is going to follow you all the way across the board and continue to follow you once you apply for a green card. Bottom line, honesty is the only policy with immigration. Honesty is not the best policy with immigration. Honesty is the only policy with immigration. What would be the consequences? Well, the first consequence would be that if you indicated under the penalty of perjury on your application that you were married, and then you came here and you married somebody else, well, that US citizen who you have married now, how could they marry you, right? You said that you were married under the penalty of perjury. So where's the divorce judgment for that other marriage? That's the first consequence, right? The US citizen spouse that is now petitioning for you might have their I-130 denied because you don't have a divorce judgment. That's consequence potentially number one. And suppose that is something that is rectified with an admission or some other kind of clarification that, well, actually, there is no divorce judgment here. I was never really married, and I didn't know what was put on the application. I just signed off on it. Well, you can't put the blame on the travel agent that actually prepared it for you. The signature is yours. So ultimately, what I've seen, the USCIS will ask you for a waiver, and that is predicated on extreme hardship. That would be another future video concerning how I could actually obtain a waiver, or also colloquially, forgiveness. I hope you like this video. Again, to summarize, I know I mentioned it and I beat it to a dead horse. Honesty is the only policy with immigration and any US Embassy officer. Thank you, and I hope you like this video. Smash the like button or you leave your comments below.